Fine print contracts. We all sign them, or we all click on. There are trillions of dollars every year of consumer transactions. Sellers sell, buyers buy, that go through these fine print contracts that almost nobody ever reads. Sometimes they're page after page. Your credit card contract, your hospital service contract, your car installment loan contract, your landlord-tenant contract, contracts that deal with everything that you engage in the supermarket of the market economy. And guess what? These contracts are all one-sided, tremendously one-sided. Almost every paragraph says, you're the one responsible, the buyer, not the seller. You're required to waive liability in case you want to sue, or you waive trial by jury, or even worse, you're expected to agree to compulsory arbitration. Or they can change the contract unilaterally at will, the way airline companies do in terms of frequent flyers. You're presumed to have agreed to all this, and the courts have bought that absurd legal fiction. Even law professors don't read these agreements. And why are they important? Because what they do is they disadvantage you in a non-competitive market. American Express, Visa, MasterCard, they don't compete on these fine print contracts. GM, Ford, Toyota, they don't compete on their fine print contracts. Hospital Corporation of America, insurance companies, they don't compete on fine print contracts. So you're dealing with an ultimatum. You can't cross the street to a competitor and get a better deal. Now, why doesn't the media cover all this? It is significant. It affects everybody. There are hundreds of billions of dollars down the drain as a result. People's rights are stifled. Well, first it starts in law school. They only spend about a day out of the contract course on fine print contracts. Why? Because there's no money in it. When the law students graduate, they want to represent big business against big business, suppliers. They want to represent distributors. They want to represent labor unions, government contracts. That's where the money is. And so they don't come out as educators of their clients or of consumers because, of course, they sign on the bottom line too. The second problem is the consumer groups have never been able to figure out how to make this clear, exciting, and compressible to the media. Now, the late Peter Jennings, who was the anchor of ABC Evening News, did, over 10 years ago, show how it could be interesting. He had a 5-part series one week on contracts of adhesion, as the lawyers call them, or standard form contracts. But the other media didn't pick up on that. And so what we have to do is show people in the media that A, it's important, that shouldn't be too hard. B, that we really protest, which means as consumers or as civic leaders, we got to raise the expectation level. Because we all grow up contract, corporate, fine print, sign on the dotted line. We grow up expecting to be contract peons, we don't use those words, or to enter contract incarceration. So we got to raise the expectation level. Isn't that the beginning of all movements for civil rights, civil liberties, environment, you name it? We got to raise the expectation level. And then we got to go to the reporters, and we got to go to the consumer columnists, and go to the TV and radio people and say, look, don't you sign those same contracts too? And they'll say, of course. And then they'll give you some complaint and how maybe they thought they might go to small claims court or something. And then they tell you the reason why the press is excluding this massive subject, apart from their advertisers, is that the press has these same contracts. They have contracts like that with their employees. They have contracts like that with people who buy their products. And all the advertisers have these kinds of contracts. It's not going to bite the hand that feeds them. And so over the period of almost 80 years, the incarceration of the consumer has gotten worse and worse. We've lost our freedom of contract, one of the 2 pillars of American private law that we're supposed to be able to invoke and have a meeting of minds between vendor and purchaser. Have you ever met the mind of Walmart or of Aetna? Have you ever met the mind of General Motors? Hardly, not in the fine print contracts. We got to make it exciting, understandable, and change the whole nature of negotiation and bargaining in the American economy. So there is a level playing field. And we need model consumer contracts in plain English that get rid of these restrictive phrases and these suppressions of our legal rights and remedies.